Mr. Justice Breyer has written The Court and the World, a particularly interesting topic this week, last week, next week, last year, next year. And I remember once you invited me to sit in on a Supreme Court argument. It happened to be one in the book, which was juvenile death penalty. And what was most interesting was a colloquy amongst the justices, because Scalia was asking the poor attorney in front of him, why would we consider international law? Justice Ginsburg was saying, why wouldn't we? And Justice Kennedy ended up writing an opinion that cited the thoughts of the world community. So why don't we begin there and talk about why is it that the court looks at international law and the opinions of the world?
There's no alternative. Mm-hmm. I mean, what the book contains, there are quite a few examples. And what I'm doing is writing this down for other people, not necessarily lawyers and judges, preferably not. But that's part of the audience. Because what I want to do, and Brent Scowcroft knew we were sitting across from each other in the train, and he had to listen to this for a while. But the point is that we have a set of problems, not all of them. I mean, it's 20%, 15% of our cases. Maybe that's a much higher percentage, I believe, than it was 20 years ago. But if you look at those cases, you will see that there is, I think you will come to the conclusion, that there is no way to resolve the legal problems involved without knowing something about law or practices or something beyond our shores. And I think anyone would come to that conclusion, not in every example, but in quite a few. And once you're there, you will be forced to ask the question, not as much as we'll be forced to ask the question, but you will ask the question, how are they going to find out? How are they going to get the necessary knowledge? How will we get these 9 people who, after all, don't know much about it, none of us, to come to conclusions that are not counterproductive in terms of the aims of the United States and other countries to deal with problems that are beyond one country's ability to deal with them? I mean, I can go through a lot of examples. How many do you want me to go through? One?
Well, actually, why don't we start with the national security examples?
All right, that's a good one, because that's what I really
relevant this week.
Perfect.
In fact, you begin, like any good Aspen seminar, by quoting the classics, which is Cicero saying, what, in times of when the guns start to roar, the laws fall silent, meaning the courts have to defer to commanders-in-chief in times of war. How do we balance that?
Yeah, I did begin that. I'd said, Cicero said, when the cannons roar, the laws fall silent. Now, that's a pretty good translation, until someone said, look, the Romans didn't have cannons. You don't know what you're talking about.
So I said guns, yeah.
But you get the point. Well, that was pretty much the law for a very long time. Mm-hmm. I mean, certainly in the Civil War. And you can understand it. Abraham Lincoln had to keep the country together, but his Seward, I think, was Secretary of State, called in the English ambassador and said, I can push a button here and get any man I want thrown into prison in New York. I can push it twice, and anyone I want in Indiana can be thrown into prison. And tell me, does the Queen of England have such power?
Right.
And the court did get involved in the Civil War cases after the war was over. Oh, that's easy. Try while the war is going on. And he put, there were about 18,000, 20,000 in prison. Go up through World War II, you'll find the same circumstance. The court stays out of it. You say, well, that made sense. They don't know anything about it. Did it? In World War II? See, in this area, I think it's important to begin with some history. In World War II, 70,000 Americans of Japanese origin, another 40,000 who weren't citizens, were removed from their homes, as we know, in California, and put into camps. Well, hey, I met Korematsu. He brought the case, Fred Korematsu. I met him next door at my house in Cambridge, because our next door neighbor was the daughter of Ernie Besig. Mm. Ernie Besig, aside from playing poker with my father, was the head of the ACLU's Northern California division and represented Fred Korematsu. And Fred Korematsu is a feisty guy, and his parents said, don't bring this case. They were in the camp. Mm-hmm. He says, this is America. I read some of it, it's great. And he says, I'm going to win this. The ACLU would not have its name on those first briefs. They did eventually. Remember, it's World War II. The Japanese have just invaded Pearl Harbor. And this is January of 42, February of 42. And the general in charge of the Presidio, DeWitt, said, we're going to move all the Japanese, supported strongly by Earl Warren. The only one against it? J. Edgar Hoover. Mm-hmm. He said, we don't need it. Mm-hmm. Don't worry. And Warren later said it was one of the worst things
but the court...
no, the court said what? The court said 44, no risk. It said keep them in prison. It's okay. Constitutional. So there was no basis. I mean, it's a very interesting story.
You call it one of the 3 worst decisions, I assume,
it's easy to
along
say.
with
We're
Dred
not
Scott
in the
and
middle of the war.
Plessy.
Of course I can call it that. Everybody calls it that.
But then how does that apply to Guantanamo? Because you're in the middle of this war.
That's exactly the problem. That's exactly the problem. Why did the court do that? My guess? They think somebody has to run this war.
You're talking about Guantanamo now?
No.
Oh.
I'm thinking about Karamatsu. Mm-hmm. This was black. It was Douglas. It was Frankfurter. The only dissenters were Jackson, Murphy, and Roberts. And they said, what? I think they're thinking somebody has to run the war, Roosevelt or us. We can't, so it's Roosevelt. So for several years, they have the Nisi fighting in Italy on our side, and their parents are all in jail up in, I mean, unbelievable. Okay, now where does it stop?
Well, yeah,
it stops in
Korea.
Guantanamo. It stops.
Too.
No, we're not there yet.
Okay,
it stops in Korea. You know, I hope you have all afternoon.
Yeah, that's right. All right. We'll go.
It's filled with interesting stories, but it stops in Korea, where the steel seizure case involved the president seizing the mills, and the Supreme Court, Jackson, says no, you can't do it. You've gone too far. All right. And he has some interesting law there that's stood up for a long time. But what he's really saying is, no, you can't go that far. What about Korea? This is taking weapons away. He wanted to he seized the mills to stop a strike. The strike would have meant that there weren't weapons going off to Korea. Well, they said, well, we're not sure about that, but this goes too far. All right? Now, and Jackson, by the way, says, you want to know some law on this, what the law is, what the founders thought? He said, trying to find out what the president's powers are in this kind of area from the founders or precedent. He says, like asking Joseph to interpret the dreams of Pharaoh. Quite right. There isn't. I mean, you don't know what that law is because the courts stayed away from it pretty much. But this, I think, retrospect tells us this is an important turning point. Then Guantanamo, 4 cases, each brought by a person who's being held in Guantanamo. The court starts and says, you can hold people who are enemy combatants. That means like the Germans in World War II or the Japanese in World War II, while hostilities are going on. And these were all people who had been seized during a hot war in Afghanistan. So they started basically assuming that point. And the question was, could Congress pass a law which says they can't use the courts? They had passed a law. The court said no. We said you can't. It violates the principle of habeas corpus. What happens if, in fact, one bin Laden chauffeur or the equivalent says, I wasn't an enemy combatant. I was a farmer, picked up just to get some money by the person who captured me. The army says, all right, why did you have a Kalashnikov? He says, look, in Afghanistan, the farmers have Kalashnikovs. But there's an argument, in other words. How is it decided? The court says, neutral decision maker, opportunity to present proofs and hear the other side, elements of due process. Right? And there, see, all 4 have won. These 4 are not the most popular people in the United States. Bin Laden driver is not the most popular person. And the president or the secretary of defense have lost. Key language to me, the Constitution does not write the president a blank check, not even in wartime. Now, that's good on a daytime radio television program. But it leads immediately for anyone here to ask the question, fine, what kind of check does it write? Yeah. And why did we not go further, as we've often been criticized for not going further and explaining what kind of check it writes? The truthful answer? Because we don't know. That's why. We don't know. It'll come up slowly, case by case. So there's a long wind-up, and there's a little pitch. And the little pitch is, right, if you had to predict. I mean, I hear yesterday, we will stop, well, I won't say where I heard it and so forth, but we will stop, we must stop X, a foreign group of dangerous people, from using the internet. For what? And how? And will that raise a legal issue? Well, we must protect our privacy from what? From intervention. I mean, in what form and under what circumstances? Well, we must have a kind of preventive detention. When, where, and under what circumstances, who and how. Now, I'm not making a point as to how those things come out. The point that I'm making is there is a system that makes it possible that you will have 9 people deciding that kind of thing. And unless you want to go back to Cicero, unless you want to have those 115,000 or 90,000 or 70,000 American citizens at the president's discretion just put into prison, you are asking those 9 people to make a pretty tough decision. And now is a total cop-out, because I'm saying I don't know the answer. But I do know you don't want 9 people who don't know anything about it. I mean, in some cases you can deal with that, because it's a basic principle and it's not that much of a problem. Some cases, I suspect you can't. And you have to know something. And there has to be a way of getting information to the court. And what is it? And that's why I say it's just as likely that you will have a key to this problem as that a group of lawyers will. Some lawyers will, some will not. But law schools, lawyers, is there some group of professionals who actually are involved in international security and intelligence problems, who every day understand what France is doing, understand what Britain is doing, understand what Israel is doing, understand what they do in other democracies that have somewhat similar problems? How similar, I don't know. Have similar constitutions, have similar kinds of, all right, there might be such people, but they're few and far between. I suspect, because I asked a few when I was writing this book, and it seemed to me I got pretty quickly to a blank. And therefore, I have written part of the book to say, please, we have not necessarily come up against these right now. We may have dealt satisfactorily with what we've had so far, or perhaps not always. But if we're going to go into a world where the national security problem is beyond our frontiers in major part, where it is indeed serious, where, in fact, dealing with it may, to some degree, infringe traditional boundaries of civil rights, it's not enough to say the president and Congress are in charge of national security, which they are. Give them a blank check, korematsu. You say, no blank check, well, now you're in the realm of people who protect civil liberties in principle, recognizing the nature of the problem and the powers of the other branches. And now that's where we are. And what I'm trying to do in that part is bring people, from what I see, up to speed on matters that may, in fact, involve our court. Have in the past, no clear direction, problem for the future, and there we are. Okay, that's what.
So you're saying, if I may paraphrase, and correct me if I'm wrong, that there are no bright lines. You can't have a bright line doctrine, because you're going to have to do this pragmatically on a case-by-case basis, and you're going to need technical expertise, not just from overseas, but on complicated issues. So let's go.
There's a good chance that that's so. I don't want to be absolute about it. I'm saying there's a good chance that that's so.
So if that's the case, do you have to, let us say, and let's not get into any cases you might have, but that there would be this balance you talk about in the book between providing security and providing the liberties. And that balance involves how much technology can be intercepted, like NSA questions, Snowden questions. Do you have to now understand the technologies of end-to-end encryption to know what a mass data gathering would do, what metadata is? Is that going to become part of a Supreme Court job?
Don't know.
Yeah.
I don't know. I know enough about it to know it's possible. And I know enough about it to think it would be terribly nice if there were a group of really good experts who know, who have different instincts on the civil liberties part maybe, and that they know enough to answer that question. And at the moment, I think that there aren't those people there, whether they're in law schools, whether they are, I mean, maybe there are, but I haven't seen it. And you want us to answer this in terms of some absolute principle, I'd say that can be done. That can be done. And, but I hesitate because that is my instinct, because I think there are some cases, for example, the Fourth Amendment says you have to have a warrant before you can arrest someone. Well, suppose the policeman sees some man or a woman being dragged into an apartment screaming like mad. Do you think he waits for a warrant? Of course not. Does that violate the Constitution? Of course not. I mean, nobody thinks it does. And so what you have in the language of the Constitution are words that in certain circumstances lend themselves to some absolute thing, but many other circumstances do not, and are filled with all kinds of exceptions. And somebody who are not exceptions, but it bends this way, bends that way, and as you say, it's pragmatic to a degree, but that's, I mean, it shouldn't be terrible that we have a tough discipline law. You know,
so
it's
how
somewhat
how does the Fourth
subtle.
Amendment, how have you been interpreting it over the years, involving anything from the right to look at an envelope of a piece of mail but not open the piece of mail without a warrant, and likewise look at the metadata of communications without
we have
opening?
Sometimes.
Yeah.
We have
So
sometimes yes
explain
and
how that's
sometimes
done.
no. You want to find out what the power of the president and the Congress is to restrict the traditional civil liberties in times of national emergency or security. To what extent is there bend or flexibility or room? When you say, what do we do when cases have arisen which involve requiring that balance to be made? And my really unsatisfactory reply is to re-quote what Justice Jackson said. The number of cases where you can find pretty clear precedent, well, here's what they tell you. Joseph, interpret the dreams of Pharaoh. Go read Steele Seizure. It's a fabulous case, filled with interest. And when I came out of it, that doesn't mean I'm right. But I came out of it thinking, of course, I think what's driving the court is they have seen World War II, President Roosevelt assuming enormous power, rulers in Europe who grabbed power, not to anyone's advantage, and they don't want to say the sky is the limit. And they don't want to say that this is whatever the president thinks. And they also have circumstances where perhaps President Truman wasn't quite as popular as President Roosevelt, and the Korean War was not World War II. Who knows? All those things are there. And when that was a very interesting point in that case, before Judge Pine, where the government came in, and every attorney general says, Roosevelt's AG, who was Biddle, wasn't it?
Yeah.
He says, every president has felt during time of national emergency, I must solve this problem of war. I'll worry about the Constitution later.
But that's the
And
job of
that
you
is what
nine.
they think, he says. And when Truman sees the mills, Jackson says in conference, because Baldwin, who was the Attorney General, AAG, arguing the case before Judge Pine, Pine says, you're really saying that in time of war like Korea, the president can do anything he thinks is necessary. What are the checks? And Baldwin said, This is what did him in. He said, no, there are checks, the ballot box. And what Jackson, looking at that, says in conference, the boys who are for all power to the president are in charge again.
Yep.
That's what he said. And then they said, but you were one. He says, that's when I had a different job. He says, I was Attorney General at that point.
It is true that people go from office to office.
Yeah,
They do
yeah,
check.
it was
But
very
also you said a moment ago
I just avoided your
that
question
you
without
have
the
to
answer.
bend and weave sometimes based on circumstances.
But that's in the Constitution.
And that's in the Constitution. So does that mean, on a very practical way, that when Paris happens or San Bernardino happens, you have to read the papers and watch the news and say that might actually affect what we have to do?
I don't have to read the papers, though I do. I don't have to watch the news, though I do. Do not worry if there is a statute passed or a regulation as a result of Paris, which is trying to prevent the same thing here, and should it infringe significantly upon traditional areas of civil liberties and appear to the government to be justified, I don't have to read the papers. Believe me, they'll tell us in the briefs. I mean, they have plenty of good lawyers, and indeed what I've learned over time is by the time you finish reading 30 or 40 briefs in a case, in a big case like that, there will be 30 or 40, and maybe more. What you discover is, I don't mean to be critical, but the papers sometimes have not got it quite right.
Leave aside the newspapers. I shouldn't have thrown journalists into this mix. But let us say that there's a certain predisposition on gathering data, whatever it may be. And then Paris happens, San Bernardino happens, and from that, the briefs tell you, not the newspapers tell you, that it's because these type of laws were changed that we now no longer can track things. Does that affect constitutional
It normally
principles?
does. Of course it does, because the Constitution has given to the president and to the Congress the power to protect us in times of national security risk. You know, I mean, Jackson said that. That's a basic principle of law reduced to a slogan that the Constitution is not a suicide pact. And the provisions of the Bill of Rights are read in light of that. But they're there. I mean, and the way normally you deal with this, maybe that's all that's necessary. Lawyers on both sides make their arguments. And on the civil liberties side, like the lawyers for Guantanamo people, I tend to reduce what they've asked to two basic questions. When there is an infringement, or say a loop goes in this way, call it flexibility, call it whatever you call it. The lawyers will ask the government, why? Why do you need it? And then if they get a good answer to that, the question is, why not? Why not do it this way, which is less infringing? Now, those two questions themselves, which are very helpful, can, in some circumstances, themselves give rise to problems which have been exhibited in Britain and elsewhere. Suppose the answer has to be classified. How do you deal with this? Do you present it to the judge in camera? In Israel, what they do, where they have a West Bank problem, is they have a system, roughly, that works as, we'll put this person in custody, person X, because we think he's part of a gang to blow up the cafe. Well, what about his lawyer? No, we're not giving him a lawyer. Why not? Well, he'll say to his lawyer, tell my mother I'm fine, and that means blow up the cafe. Well, suppose that is a circumstance. Or they have a system where the army can try to persuade the judge that that's necessary to deprive him of a lawyer for a couple of days or for some period of time. Is there a lawyer representing him in the room? No. Well, how do they deal with that? They say, if I'm convinced you're right, Army, come back in 5 days and tell me again why you still can't give him a lawyer. And each time, make the days shorter. And each time, make the burden he has to show harder. In Britain, they have a system that works roughly as follows. They give him the lawyer, where he was not a Brit, he was not a citizen there, the people were aliens. We'll give them a lawyer, but the lawyer won't have access to the information. Well, we'll have another lawyer I heard this, we discussed this at some length, not in a case, but in a seminar. We'll give him another lawyer. The other lawyer has access to the information. But the other lawyer who can argue against the information can't talk to him, but can talk to the first lawyer. So I said, well, what can he talk about? I said, well, it's their job that the second lawyer gives the gist of what the information is about to the first lawyer, and will take any questions that the first lawyer wants asked and go ask them. Now, it's a pretty complicated system. And then there are some, I will spare you the details, but my point of mentioning Israel, my point of mentioning Britain, is we are not the only country in the world that has to deal with this kind of problem. And the more that we learn, the more that we figure out ways of dealing with these kinds of problems, and institutions that can take account of these differences and division between presidential, congressional, and judicial power, the better off we are. So that's why there's 7 chapters. Now the others are much more mundane, if you want.
They're commercial law, but we won't
That's
go
fabulous.
into those.
Why not? That's really interesting.
Well, because we're going to open it up to audience
right.
questions, and while everybody's preparing the question, I have one last question.
Right.
I saw you in the audience of Hamilton a week ago Saturday. What did you learn from Hamilton?
Fabulous.
Yeah.
I was the second time. The first time I went, I was too tired because I'd been giving a talk like this. I then went to it, couldn't understand a word. I mean, I could not understand a word because it's all in rap. So I left. Then, through very good luck, we're invited by some friends, so we go again. This time I heard every word. I would heartily recommend it. I mean, my goodness. What I thought, I mean, you don't understand. I don't come at these things with a natural inclination to say I want to hear 2 hours of rap music. That just reflects my age. But the fact is, I see it. I think, 1, it's an opera. 2, it's a ballet. 3, it's history and a story. And I thought, and the cast is, 2/3 African American, Hispanics and everybody, and they're all doing this rap. And I'm thinking, the chances of that turning into something like, how do you do, Mr. Washington? I'm Mr. That is great. None of that, not in my opinion. Nothing that you'd say this has a chip on its shoulder, you'd say it was politically correct. And I came away thinking that, man, I think, my goodness, I've now seen George Washington. And moreover, the fact that they can do this, I really was enthusiastic. The fact that they can do this, and somehow through some genius, well, there's hope. There's hope we can transmit these things, that were transmitted to us. There's hope that we can transmit them to the next generation or 2, even if we can't all sing rap. There are some people who can do that, and it doesn't have to be rap. But I mean, it was great. So I recommend it.
All right, Meryl Chertoff is here. So let me start the questioning with our person who runs our Justice and Society program.
Hi, Justice. How are you? Hi, Justice. How are you? So in the book, you have a chapter on opening the courthouse doors. And you wrote about, in some detail, Dolly Filartiga and her case. And as we all know, in the refugee camps today, there are 100,000 Dolly Filartigas or more. The 2 main cases on that, which you talked about, were the Kia Bell case and the Sosa case. And I know in the Breyer opinion, there's a discussion of who are the modern pirates. So one question is, if you were examining those cases, what would you be looking to as the sources of customary international law? And then the second question, which you asked in the book, is should the answers to this be coming from Congress? So if you were the Ayatollah, what would you be suggesting that the Congress do?
Well, clarify the statute. Yeah. I mean, that's the, and so since it may well be that Congress won't, we have to work with a statute that's 200 years old, at least, more than that. And for those of you who haven't followed this, it's a great story. And it is in a different area. It's in the human rights area. Dolly Filartiga is from Paraguay. In the 70s, she showed up in New York. There she finds in New York a man, also from Paraguay, who tortured her brother to death in Paraguay. And she brings a lawsuit against him because she also found a law that was passed in the 1790s, probably in part, to compensate victims of pirates. And it says an alien, basically it says an alien can bring a suit in an American court for the violation, for damages, for a violation of the law of nations. She won. She went back to Paraguay and she said, I came to the United States to look that torturer in the eye, and I came back with so much more. Well, good. But as a result of that case, a lot of other people began to bring cases. And that began to raise issues that are pretty difficult. I mean, who are today's pirates? Of course, that is a question. And we've limited it to try to make it the worst of, et cetera, but how should it be limited? But more than that, what's a court supposed to do when faced with such a case? If, for example, the victim is a victim of apartheid, and South Africa, as happened, files a brief that says, look, we're dealing with the apartheid problem, okay? We have truth and reconciliation, and we don't want federal judges mucking around in this. We want to deal with it ourselves. Mm-hmm. And how are courts supposed to respond to that? And more than that, how can we, in fact, get an interpretation that is generalizable if other nations do the same kind of thing, whether through the International Criminal Court or a tort suit that in European countries often goes along and is part of the criminal prosecution? It should work out. It shouldn't be a circumstance so that if country A does it and B does something a little different and C does something over here, they step on each other's toes and everything gets mucked up instead of it working in harmony. And the way that I describe that, it seems to me that the way this is normally put is if we allow this suit, then all over the world everybody is going to try to sue Henry Kissinger. Mm-hmm. Right.
The alien tort statute.
Yeah, right. That is not a happy result. It has to work out. And there is no Supreme Court of the world to work it out. Mm-hmm. And so that is an example, because if Congress acts, fine, wonderful. Then we've got the answers. Mm-hmm. But if they don't, then, and depending on how they do it, mm-hmm. you'll have judges who themselves in different countries have to take into account what the implication of their opinion is for how other countries might or might not behave. Now, that is not a new idea. There's a word called comity, which if you look in, I told you I would get this in, if you look in the antitrust area, if you look in the fraud area, if you look in commercial area after area, copyright, what you will see, I think, is courts using that traditional notion to take open words in their statutes which aren't clear and harmonize them, but not in the way they used to. They used to just ask, is this totally going to muck up the other law? I think they ask now, how can our antitrust authorities in Europe and the United States, how can our securities authorities in Australia and the SEC, how can they work together in harmony given their somewhat similar, but not perfectly similar systems? Right. And therefore we get briefs from lawyers and countries across the world trying to help us, from their own point of view, answer those kinds of questions. And that's the world as it is. I'm not saying that's some future world. I'm saying that's the world as it's been in the Supreme Court for the last 5, 10 years.
Great. Questions? So Judge Wald here. Is she? Yeah, there you are. Yeah.
I didn't have a question, but now that you've called on me spontaneously, I'll think one up.
It's a first-year law.
She's had the experience.
No, I saw no hand, so I do play the 1L professor.
All right.
She's had the experience.
Of what?
Justice
Court over there.
Okay.
Right, I know, that's why I called on her. Stand up if you would. Judge Pat Wald, yeah.
I mean, she's had the experience
I'm over
working
here.
with it.
Yeah. Okay. Justice Breyer, one comment. You talked about several of the past historical war times and the fact that eventually the Supreme Court got around to making decisions which somewhat paralleled the climate that they lived in, but showed some evolutionary progress in there. But I'm wondering how you take account of the fact that nowadays, certainly in the area of privacy and civil rights and sophisticated technology, surveillance technology, et cetera, much of it, of course, is, as you know, classified and secret, so that the people who actually are losing some of their rights don't even know about it unless it eventually ends up in a criminal proceeding, which is a minute fraction. So far, the Supreme Court and lower courts have not been particularly sympathetic to the notion of who can bring such actions. Now, the Guantanamo defendants, yes, they were in captivity. Their civil rights, they thought, had clearly been violated. But as you know, there's been difficulty in bringing any lawsuits to challenge aspects of surveillance, and needless to say, 98% of what the intelligence community does is classified. And the
So you're
victims
talking about
don't know
access to challenge the FISA courts.
Yeah, and
Not-
I think, as
not
you know,
price.
I tend to think that is a problem. I mean, the reason we had a case, Clapper, which you probably know, and the court held 5-4 that they couldn't bring the case because they couldn't show that the government was listening to what they were saying. So I'm biased in that case because I wrote the dissent. So I said, well, if it isn't listening to these people, it's not doing its job, because they were lawyers who were representing terrorists or people in Guantanamo. But that's a problem, and I guess some will be able to and some will not. If they'd followed the dissent, I think there would be more that would be able to. But it certainly didn't shut
And
the
this
door.
is
Majority.
aliens or foreign
No, it says
people
personally.
having
Yeah, yeah,
access
yeah,
to
yeah.
challenge a FISA court.
Well, they're the ones being held, and
Right.
FISA court. We haven't had cases involving the FISA court where somebody's been challenging that decision. This would have challenged a decision of they wanted to get a hold of. They were saying that the government listening to us is unlawful,
Right.
but it wasn't a decision in front of us that came out of a FISA court. It came out of an ordinary court.
Okay.
And
Yes, back there. I've already. Yeah.
I mean, Pat's been in the middle of this. For those of you who don't know,
Go ahead.
Sorry. Go ahead.
I'm Don Baker.
Yeah.
As you know, Justice Breyer, the decision of the court on which cases to take is one of the most important things that goes on, and it takes 4 justices to agree to hear a case. Yet we don't know when a case is taken which 4 justices heard the case. What is your reaction to the idea that maybe that information ought to be available?
No.
Good try.
Ex-cathedra?
Well, that's my reaction. You say, well, why not? Because there are 8,000 cases. That's 150 a week, and in a way, you'd have to start writing about why you're doing this or why you're doing that, and God knows how many, and you couldn't get the job done. In a way, we can't go wrong, because if we don't take a case, the reason we're there to take cases is primarily, not 100%, but mostly the cases that we take are cases, in the words of Chief Justice Taft, who'd been president, seen the 2 branches, knew all 3. He says, what's the Supreme Court doing here? It's not here to correct errors. Everyone in front of the court has already had a trial, at least 1 appeal, quite often 2 or 3 appeals. They don't need another appeal. And moreover, why would we be right and the others would be wrong? They say, well, what are we doing? What we are doing, what we see ourselves as doing almost all the time, is trying to iron out different interpretations by different courts of the same text of a federal statute or the Constitution. You see? And by the way, that's about 5% of American law. Almost all the law in the United States is made in the states. And we don't decide those things. So we could hear a case where the question was the interpretation, there was a comma in the Internal Revenue Code provision. And the question was, is the next word, which was for, should it be read as a which or a that? You know? Well, I like the case, no one else did, but nonetheless. But you see, there'd been different interpretations.
Yeah.
Or it could be some major Fourth Amendment issue. Now, think of that, Don. When we decide not to have a case, not to take it, suppose it was an error not to hear this issue. What will happen?
Come back.
It'll come back in another case. And suppose it doesn't come back. The country didn't need us, did it? Now, that's a little flip, but that's how people do think about it. And that reason, I think, is a very practical reason. There is enough to argue about. If you feel strongly enough about this, cert, being denied, you write something. I've written dissents from denial. I can do it. No one says you can't. Mm-hmm. And so I write it. My audience is my colleagues. And sometimes I will persuade 2 or 3 others or enough others. The case will be granted, and you'll never read the dissent. No one will. They'll survive without reading it.
Do you ever
if, by the way, I fail, I'll publish it. Who knows? Maybe
it's in the book? Some
Not
of the paragraphs here. But do you ever deny cert, say, oh, it'll come back, and the reason you deny cert is thinking, gee, it'll be better to decide this in a year or 2?
That can happen. It doesn't happen very often. But sometimes to hear a case now could, in fact, muck up something.
Process that's
There's
going.
something. I mean, it can happen. It's been known to happen. The nice thing about the cert process is that you don't normally have to have a reason given. You do have a reason, but you don't have to go through all this thing of writing it down in every case, which would be impossible. And you don't have to take a case now. Suppose I know that Court X, lower court, is just in the middle of deciding this. They've had a bunch of similar cases. They have great expertise. And if I take this case now, they'll wait, and I'll never hear what they have to say.
Did that give the justices pause on the timing of gay marriage?
Oh, I knew you wanted to ask. This is, you can't resist with a journalistic background.
But yeah, I mean.
And therefore, I will do my normal resistance.
Okay. Yes, sir. Sorry. Yeah.
Thank you very much. Charles Cobb. You gave some examples, Justice Breyer, where the court would bend the words one way or the other, and some of those examples were in the context of war. Does the partisan state of the country affect the ability or the willingness of the court to engage in such bending?
Not really. I don't think so. I don't think the partisan state does. It's not bending the words. Look, I mean, Justice Black was an example of someone who thought you just interpret the Constitution to read what it says. And it says, for Amendment 1, Congress shall make no law abridging the freedom of speech, okay? And he would point to that and he would say, you see, no law means no law. But he wasn't pointing to the right words. What about the freedom of speech? Mm-hmm. It's easy to think of cases that fall clearly within it and some that fall without. But on the borders, which is where we're normally answering the question, it's not clear normally. If it was so clear, why is there this division? See, it's not clear whether the freedom of speech done in that expression does cover it. And what about the word liberty in the 14th Amendment? And what about the words of the 4th Amendment protecting privacy? Unreasonable searches and seizures. Do you see the ways in which it comes up?
Mm-hmm. Yes, sir.
My name is John Klein. Justice Breyer, my question goes to the issue of presidential power. You mentioned in the Korean War that President Truman tried to overreach himself and the court did what it did. But in the last 30 years, it seems to me that the president has the presidents have done a whole lot of things to increase their power, including issuing executive orders. Is there something that is going to be done to readjust the balance of powers, or do you think that this will keep increasing in the future?
You mean, are we going to grant cert in the immigration case, and how will the case come out?
Yes, right. He's not a journalist, so he asked it in a more subtle way.
Right. And of course, I have no, we'll find out, including me. The general thing is, it's important to remember that we don't decide things like that in a vacuum. What we do is there is a particular case. There was a particular case in the steel case. The particular case was President Truman had issued an order seizing this particular mill, and the people who were the owners of that mill said he cannot do this. And it's in that context that we will have to face a constitutional issue. Not in a context like, is the president, we think the president is too powerful, so let's let him join him for, that isn't quite. Now, to be fair to you, you read that case with care, and you think, are the judges being moved somewhat by those considerations that you mentioned? Maybe to a degree, but you see, it's down deep. It isn't that I usually say, look, every judge, like every executive branch official, like every member of Congress, like every senator, like everyone anywhere, certainly our age in public life or not in public life, has sort of views about the area with which he deals. Now, these views are often at a very abstract philosophical level. What's law about, really? What's law about in the United States? How does it relate to us, to our citizens? What is this Constitution? What's it really there for, basically? And what is it trying to do? And you begin to develop approaches to these things. Now, that kind of thing you can't jump out of. We're not computers. We shouldn't be computers. And there is no horn book that answers the kinds of questions before us where they're really tough and difficult. And of course, people will be, to some degree, impossible to say how much or when, even in your own case. By your background, I went to Lowell High School in San Francisco in the 50s. I did, okay? And there we are. Does that shape me somehow? Probably. Shape you? No, probably. And it's that kind of thing. It's an inherent element of human nature when a person does his or her job that does have an impact, even on matters such as those you raised, but you just can't say how or even know.
Well, that's a great note upon which to end. I know there are many more questions, but you've agreed to sign your books out there so people can line up and ask a few more questions. I want to say that I noticed that this year you were in the majority in the Supreme Court more than any other justice. And in some ways it says good things about the court, and it says good things about you. So thank you very much.
That was last year, by the way.
Yeah, okay. Thank you very much, Justice. It was really good.